I'm sure. Senator Patterson, you have the call.
Thank you, Chair. It's been reported that there were 10 people who breached their visa conditions who charges against them had to be dropped as a result of the invalid nature of their visas. Just want to confirm that number is correct, that it was 10?
Senator, I'll just get the relevant people up to the table.
Thank you.
To assist. Senator Claire Sharp, Group Manager, Legal Group. Yes, the number is 10.
How many of those 10 were charged with breaching their visa conditions more than once?
I don't have that information to hand. I'll have to take that on notice.
Okay. How many of those 10 were in custody?
On which date?
When it was discovered that their visas were invalid and they had to be released from custody?
My understanding is it's 3.
3. So of those 3, presumably the reason that they might have been in custody was that there were multiple breaches of their visa conditions? Wasn't a first offence, so that might be the reason why they're in custody, or is there some other reason why they're in custody?
The reason the person would be in custody as opposed to being on bail would be because the court that's considering the charges considered that necessary.
Yes, but what is the reason why they would consider that necessary?
That would be very factual specific to the individual.
Okay. So you don't know whether any of them breached their visa conditions multiple times?
No, I said I'd take that on notice.
Were any of those 10 people who were charged with breaching their visa conditions not wearing an electronic monitoring device at the time?
Senator, we don't have that information in front of us.
Okay, so we take that on notice as well. Okay. Of those 10 people, were any of them charged with a serious crime like murder as part of their historical offences that led to their visa being cancelled in the first place?
When you use the word charged, do you mean convicted?
Charged or convicted.
So the 10 that we're talking about were charged with Migration Act offences.
I know that, sorry. To be clear, I mean the historical offences which caused their visa to originally be cancelled on character grounds, which is why they were in immigration detention, waiting and deportation. That's the list that Ms Foster provided in the last Senate estimates. It broke it down by category of offence, murder, sexual offences, etc. So of those 10, were any of them charged with a very serious offence like murder or a sexual offence?
I'm not sure that the officers monitor those two things in conjunction. We'll see if we can get you an answer to that. It also goes a little bit to the point that Mr Thomas was making before, that we need to be really careful as we start to break down people into subcategories and subcategories, that we're not identifying individuals. So we'll see if we can find you the answer and make sure we're not transgressing our privacy obligations.
Okay. How many people have now been charged for breaching state or territory offences?
Senator, I think I've already said to you we've taken that on notice previously. We'll come back to you. But that number will change daily.
It's previously been reported it's 18. Is it still 18 or is it higher than 18? I think
it will change daily because charges get dropped, charges get laid, charges get changed, people get bailed. People
okay, and I'm asking you, where are we at as of today?
So, I'll take that on notice. We don't keep a running tally, Senator. There's no operational reason for us to keep a running tally. What we need to know is somebody in the community who requires the visa conditions to be applied or not. What they're charged with, when they're charged, when the state prosecutors change charges, which they do frequently, or drop cases or amend cases, we do not need to keep a running tally on all of that, and we don't.
So, Commissioner, for the decisions of the Community Protection Board, it's not a relevant consideration that someone might have committed a sexual assault?
If they're convicted of a sexual assault, yes, absolutely. And they consider, as I said to you earlier on, they consider so much material, a plethora of material, to make their recommendations to the delegate.
So a charge is not a relevant consideration on what visa conditions are imposed on someone?
The mere charging of somebody or arresting of somebody isn't a conviction in a court.
I'm aware of that, but I'm still asking whether it's a relevant consideration for the Community Protection Board.
The cases are brought back to the Community Protection Board. where they either ask for more frequent reviews, which sometimes they do within the 12-month period. They may ask for it to bring it back in 3 months, 6 months or 12 months, or if circumstances significantly change. So if somebody's arrested, let's say, for an incredibly serious offence, and we would be aware of that, then we may well, with the department, follow up. But the mere arresting of somebody isn't in of itself a reason.
Okay. I hear you, but you just said you'd be aware of it, so why can't you provide that information to me now?
Because it changes constantly, and we don't keep a running tally. There's no reason for us to keep a running tally on the various machinations of state police and state prosecutors in terms of their cases that they're running, because they change sometimes daily.
Sure, and I'm not asking you for the up-to-minute. I'm asking you for the most recent information that you have. It might be yesterday, it might be last week. What is the most recent information?
And I said to you I would take that on notice, but even by the time I do that, I took that last hearing, it will change. It will change daily.
Yeah, but at a point in time, there is a truth, right? And it will be 18, that answers previously been given, or it'll be 20, or it'll be 16.
Have to go for a process, Senator, to contact all the states and territories and verify all the information, ask them to contact all the investigators and detectives, ask them to contact all the prosecutors to get that information verified. What we need to know in the Border Force is somebody who is subject to electronic monitoring in the community or in jail. And if they're in a jail and they're going to be released from jail, we need to know before they're released. And I can tell you, I absolutely am confident we get that. But in terms of the charges, the nature of the charge, the facts behind the charge, in every case, we don't need to know that to undertake our operation.
Well, you do need to know that to answer my question, and it is your obligation to answer questions.
And I've taken it on notice.
But you just basically said you couldn't answer that question or wouldn't answer that question because it would involve all this work conducting state police forces.
It certainly will, and like at last hearing, I took that on notice, and we'll come back to you on notice.
Okay, well, I look forward to that answer.
Point of order, Chair. It would be helpful if an indication could be given by the witness as to whether or not the witness is going to actually answer the question, even if it's taken on notice, because I am hearing mixed messages about whether or not you do propose to actually answer the question, even if it's taken on notice.
We'll attempt to answer the question, Senator, but my point is that there is providing a running commentary of prosecutions over which we have no control, and visibly nor do we need to, is not easy. It's a lot of work. I don't need to do that operationally. I'll see what I can do for the Senator to answer the question, but it's not information that I have at my fingertips, nor do I need it at my fingertips.
Commissioner Outram, you're a very experienced public servant and an experienced witness. Even if you think this information is not relevant for you operationally, it doesn't mean it's irrelevant for the Senate's consideration of the public policy issues that we are here to ask you questions about in estimates. And the only valid reason for you to not answer a question is if you want to make a public interest immunity claim and specify the reason there is harm to the public interest from not answering the question.
And Senator, you're asking me for information that's in the domain of the states and territories, not within my organisation.
Well, except that you just said a few minutes ago that you would know about it if it happened.
What I said, no. I didn't say that.
Well, we can go back to the Hansard and we can check the exact form of words, but what I understood you to mean was you would be aware if this would happen and it would be a relevant consideration.
I would be aware of somebody being remanded in custody who was subject to the visa conditions. I would be aware of somebody who's remanded in custody being released from custody who is subject to the visa conditions. The details of the offences they've been charged with, the status of the prosecutions, the status of the court cases, the status of the witnesses and all those things.
I haven't asked for most of those
things.
No,
but the information, you're asking for a running commentary on all of the cases.
No, I'm not. No, just one question. How many of them who had been charged with a serious offence like murder or a sexual offence and then were charged with a state offence?
And I can't answer that because I've got to go and ask the states and territories.
Okay. How many of them were wearing ankle bracelets?
How many of who, Senator?
Of the 18 or more people who were charged with a state or territory offence, how many of them were wearing ankle bracelets and how many weren't?
Again, I will take that on notice because what you're asking me to do is firstly identify a point in time at which any of the 150 have been charged with a state offence, assuming that the charges are extant at that point in time, and then to check at that point in time against how many of them were subject to which visa conditions, including electronic monitoring being one of those visa conditions.
Commissioner. You are responsible for the monitoring of these detainees in the community via their electronic
movements,
bracelets.
yes.
That's right. And so if someone was charged with an offence, I reckon it might be quite helpful to police, for example, to know that they were wearing an ankle bracelet and where they were. They might have even asked you for that information as part of their investigations. That should be a very straightforward question to answer.
Well, it's not, because we're enforcing the monitoring of the person who's wearing the device, and we're monitoring their movements through that device. And the police know the details of the 150, and we have a mechanism in place that if one of them becomes arrested or whatever, then of course my officers will be informed about it. But we don't need to keep a dashboard. Senator, if I can just finish, please. We don't need to keep a dashboard that gives us an hour-by-hour run.
I'm not asking for that.
But you are, if you see, because we would be receiving that information, absolutely, but do we need to keep a dashboard of all?
Okay, let me try and be helpful.
We don't need to keep a running tally. I need to know, and we need to in the Border Force, where they are, and can we impose the conditions on them that have been through the visa conditions.
Let me try and be helpful. You have two lists within your possession, a list of detainees who have ankle bracelets, a list of detainees who do not have ankle bracelets. Of the ones who don't have ankle bracelets, find out whether any of them have been charged with state or territory offences. You'll have their names, state and federal police will have those names. I don't need to know those names. I just want to know, were they wearing an ankle bracelet when they were charged with
So
offence?
I've taken that on notice at the previous hearing, and we will endeavour to come back to you, but the information that you want isn't information that I own. I have to go and ask state and territories. Their prosecutions.
You've made that
not my
point. I
prosecutions.
want to move on to other topics, Chair.
Well, you have one more question.
Thank you. How many community safety supervision orders or community safety detention orders have been applied for?
No.
Okay. Thank you, Chair.
Senator Shivich.